First case is case number 524303, matter of John Doe versus Skidmore College. Please be seated.
Just give me a minute, thank you. I just like to start by welcoming everyone to the Appellate Division, 3rd Department. For those of you who have not previously appeared here, good afternoon, and we ask that if you are the appellant and you wish to reserve time for rebuttal, please let me know that at the outset before you begin your argument. People always forget that, but let me make that clear. Please ask for rebuttal time at the outset before you begin your argument. The other thing I'd like to advise you of, we were the first court to begin live of the appellate divisions, to begin live webcasting arguments. Your clients and other people in the firm and whoever you might like, and law students, anyone, could be watching your argument from, far and wide. Be aware of that if your case involves sensitive matter, non-party witnesses. We have read all the materials in the case briefs. You need not use names and so on, but reference people by their title or, the child, the grandchild, the second child, that sort of thing, to protect people's privacy. Be mindful of that. Thank you very much, and without further ado.
Good afternoon, Your Honors. I'm Victoria Graffio, and I'd ask to reserve 2 minutes of rebuttal, please. I represent John Doe, who was a senior at Skidmore College when he was advised that there was a sexual misconduct complaint that had been filed against him involving an incident that had happened a year and 9 months earlier. Regardless of whether an accused student is innocent or guilty of the charges, I think that the issue in this case that we really need to focus on is the fact that in order to ensure the integrity of the process and the legitimacy of the determination, colleges must adhere to the policies that they've promulgated. In this case, right from the onset of the investigation straight through to the determination of penalty, the college violated its procedures. There were quite a number of very serious deviations, which I think resulted in the lack of fundamental fairness and the loss of impartiality.
They need to substantially comply. If you could, and I know will do this, but what's the most serious in your view? Bring us right to the heart of what's the most significant deviation?
Well, I have 3, but I'll try to emphasize. But let me start from the beginning of the investigation because it kind of moves through the whole process. There was no adequate notice here. If you notice that the record at page 85, the handbook states that the responding student is supposed to be supplied with a detailed statement of the facts supporting the alleged violations. In this case, John was only supplied with a reference to the 2 sections.
Right, and no details, no facts
factual
whatsoever.
allegations.
And at what point does he in fact get those facts?
Well,
It's
not before he was interviewed. So at the time that he gave his interview with the investigator, he had no idea what specific conduct Jane was alleging. It wasn't until he had the first draft report that he had any idea. But the second, I think, most egregious offense here, I use that word lightly, but I think deviation of policy ties in with that because you could not reconcile her statements. We have very, very serious contradictions in Jane's remarks as these 2 months go by. We start with the fact that immediately after this alleged incident, she tells her friend that she didn't have any regrets for what happened and she did not have sex with him. This then morphs into, well, it wasn't an assault because I could have stopped it if I wanted to. And then we end up with the final report where she has allegations of multiple penetrations.
Wouldn't that be within the finder of facts, essentially their discretion to resolve those differing?
But they didn't. At no point does the record reflect that they ever questioned her regarding why are these contradictions? Why did the story change though? And they put all these witness statements, which these witnesses did not fit the definition of witnesses under the guidelines. It's supposed to be people who were first told or people who have relevant information. They put all these hearsay statements into the final report, and when she appeared, not one member of the panel asked her a single question about all these contradictions in her statements, all these embellishments that occurred over 2 months. Also, when she was interviewed, as the appeal panel found, there was a significant error because they interviewed her with her girlfriend there. And her girlfriend later sent an email to the investigator claiming, well, everybody in the room knew it was rape. That was a highly prejudicial statement. John's attorney asked for that to be redacted. The college refused to redact it. It was submitted in a complaint, a different complaint. I mean, it never should have been part of the record.
So the three most significant deviations that would constitute this substantial: no adequate notice, the statements that were not reconciled in the process, multiple statements not reconciled, and this deviation relative to that witness.
We also have a split policy that was applied. He was charged under the 2013-2014 policy, which would have provided him with a hearing. You just had 2 SUNY cases this winter. Both those cases involved hearings where there were witnesses who were cross-examined. Under the original policy that he was charged with, he would have been entitled to a hearing with witnesses. They switched midstream to the 2014-2015 policy. They did away with the hearing, and instead they submitted this lengthy report with all this immaterial and irrelevant statements as part of that record. He was not allowed to bring his attorney to the hearing. The school was well aware that he had counsel throughout this entire process. His attorney had written a letter on December 3rd to the college, which is certainly in the record, mentioning all the different violations that had occurred during the process. They claimed he was 90 minutes late advising them that his attorney wanted to be with him at the hearing, and they denied his attorney access.
So no latitude given to him in a significant manner. I'm confused, and if you could help me with sorting out which of the guidelines is supposed to be applied here, in your view. We've got the, it's 2013-14 and 2015-16, and I may have misstated the dates.
I think they should have adhered to the 2013-2014 because that was the guideline that was in effect at the time of the incident that she charged. And also, the enough is enough law became effective prior to the adjudication panel here, and that also allows colleges to have a hearing. Granted, it allows the school to opt to use some other process, but I think that denying him the hearing, since that was what was governing at the time, it's not his fault that she waited 1 year and 9 months to bring the complaint. If she had brought a timely complaint, there's no question it would have been under the 2013-2014 process, and he would have been entitled to a hearing. And
what do we
would have
do?
been able to present witnesses and cross-examine. I'm sorry.
What do we do with the fact that it was 1 year and 9 months later? What is the significance of that component of this?
I think that ties in with the fact that you had all these other witnesses that were making comments and were kind of influencing her. I presume there's somewhat an inference in the record that perhaps her story changed over these 2 months because so many other people were in contact with her and talking to her about what happened. All her initial emails and discussions indicated that these events had not happened. As a matter of fact, there were even email messages that she withheld from the investigator. It was other witnesses that gave the investigator some of her text messages. And, one of them being, I think, pretty important. So I think that the 1 year, 9 months does not mean that you can't file the complaint, but I think it certainly meant that they should have questioned her regarding these contradictions in her statements, because, fundamental fairness is really the objective of this whole process.
Before you run out of time, assuming that we find that this college, it was supported by a rational basis in the record, and it wasn't arbitrary, given that they applied the 2015, 2016. Could you speak to the appropriate sanction? Because with the sanction, it talks about a pattern, and it looked towards the prior behavior of the student. Could you speak to that?
Yes, I would say that that also was a violation of the policy. If you look at their policy, it clearly has two conditions before they can consider any kind of prior behavior. It has to be substantially similar, and there has to be a pattern, as you mentioned, Judge. What they claim to be the substantially similar violation here in no way has any bearing on the charges that were here. He was a tutor. He had a group of students. There was a young woman he was interested in. He made what, I'm going to tell you, there were comments he should not have made. She found them objectionable. It was not a complaint. She wrote an evaluation afterwards. He paid the price for it.
Was it sexual in nature, the comments?
I think they were more in the nature of bantering, flirtatious comments. There was no physical touching. There was no sexual activity. Other students were present at the time. This instance involved, two students alone in a dorm room for 4 hours. You're writing out the words substantially similar if you're going to claim that comments that a lot of college students make, regardless of how inappropriate they are, should have been used to enhance his penalty here. I think they did not follow their policy right straight through to the penalty phase.
And at that point, if you want to save your time, I allowed a little extra because of the question.
Thank you.
Good afternoon, Your Honor.
Good afternoon.
My name is Robert Manfredo from Bond, Chennick & King, and I represent Skidmore College in this matter. I'll jump right to the heart of the case and address the areas where the petitioner has found or has alleged that there has not been substantial compliance with respect to the policy. The first being the issue that the college did not provide adequate notice of the charges. The policy actually does not require a detailed factual recitation of the allegations.
But I'm having difficulty, as my colleague brought up. Waited a year and a half. Now he's a senior.
Sure.
And this is when you start the investigation, the process against him, and then ultimately expelled him, and he's a senior. Why wasn't it done a year and a half earlier? What's the point in expelling him now?
Well, Your Honor, the complainant in this case, Jane Doe, filed her complaint a year and 9 months after the incident occurred. And the reason she gave as part of the investigation was because she was dealing with the trauma of this incident. When she came back in the fall after this incident had occurred, she realized that she became very close with a woman who was identified in the investigation as witness 2, who was at that time dating the petitioner, and realized that she needed to get this off her chest. She needed to explain what had happened, and felt as though she at that point was strong enough to talk about it. She did actually report it anonymously to the college in February of 2014, so less than a month after the incident actually occurred. That anonymous report, they act as a confidential resource. They're not permitted to initiate an investigation and an adjudicatory process. The policy itself does not have a time limit on the filing of a complaint. Some colleges do implement a time limit on when you have to file the complaint by. Skidmore's policy does not have such a time limit.
But relative to the penalty and following up on that question, I mean, the incident that was taken into account, can you find that substantially similar? The facts are so disparate. Was that at all fair? How can you support that?
Respectfully, yes, Your Honor, it was a fair punishment. The policy, as you mentioned,
Substantially similar. That's what I'm.
Substantially similar, yes. The conduct at issue was sexual harassment of another student. The petitioner actually waived his right to participate through a comprehensive investigation and adjudication of those allegations and opted to simply go through a sexual harassment training in lieu of going through the full process.
So sexual harassment and rape is similar?
They are identified as sexual conduct that are both prohibited by the college's policy, Your Honor. The comments at issue were sexual in nature. He had mentioned to other students that this particular young woman had flashed her breasts at a McDonald's worker. He had made comments about the woman's physical appearance. So while, yes, there was no physical penetration like he had with the complainant in the other complaint, they were sexual in nature, and the college felt as though it was appropriate to consider that as part of the evaluation of a penalty.
But since the incident happened in a year and a half earlier, why shouldn't the policy that applies to him is from 2014, what is it, 2013 to 2014?
Right.
Why are you applying the policy when the investigation officially starts?
So the determination with respect to which policy to apply, really, when the college looked at it, the actual incident occurred in January of 14. At the time, the 13-14 sexual misconduct.
I'm sorry, is the punishment different depending on which policy?
Well, so the policy, in evaluating the appropriate policy, they looked at the procedures for the 15-16 sexual.
Is the punishment more severe depending on what year the policy is?
No, they have discretion with respect to they had discretion under either policy with
So
respect
what's
to
the big
penalty.
difference between the policies if it's 13-14 versus 15-16?
Both of them gave discretion to the college to evaluate an appropriate penalty based on the nature of the offense. So it had no whichever policy was applied had no bearing on the way that they would determine the appropriate sanction.
But the big difference is getting a hearing. Isn't there a big difference between the two policies?
There's a very big difference between having a full-blown hearing and the investigative model. That being said, the enough is enough legislation and federal guidance does not require that a college provide a full-blown hearing like SUNY has in the Potsdam case.
So you don't have to give them a hearing if you do the 15-16, but if you do the 13-14, you have to give them a hearing.
The difference between the two policies, if you look at the 13-14 policy, it doesn't have as complex of an investigative model as the 15-16. So 15-16 actually contemplates interviews and allows the participants, the petitioner and the reporting individual, the complainant, to submit questions back and forth to one another, which is actually the preferred method by the Office of Civil Rights. In their guidance, that's the preferred method, that the students submit questions to the
But
investigator.
had she reported it in 14, he would have had a hearing.
He would have had a hearing had she reported it in 13-14.
And there was nothing stopping you from applying that policy when you started your investigation.
There was, Your Honor. We could not apply that policy because at the time, the enough is enough legislation had gone into effect. The college at the time had substantially overhauled the policy to provide for a to comply with the enough is enough legislation, which allowed for this investigative model, which is an approved and very acceptable model for the college to use, and it's widely used among other colleges. It is, I think, in my experience, a rarity for a college to provide a full-blown hearing. The idea being to avoid cross-examination of the reporting individual and witnesses.
Counselor, so under the newer policy, it's more difficult for the accused to challenge the credibility of the complainant. Is that correct?
Not necessarily. In fact, the 13-14 policy didn't provide for cross-examination, so he wouldn't have had the right under either policy to question the complainant directly. It would have the hearing when it's not. The hearing under the 13-14 policy is not a hearing like you would normally think in a court of law. The 13-14 policy allowed for questioning by the adjudication panel directly to the students. So the students would sit in a room and the panel itself would direct questions and they would respond. The difference now is that they have a commenting session where the students are provided 15 minutes to address the panel directly. There's no questioning that takes place.
So there's no challenge to the credibility. The credibility isn't tested.
Under either policy, you would not, there's
Well,
no
if there's
cross-examination.
questions from the panel, credibility is tested.
But the panel has the right to question the credibility. The panel has the right to ask questions of both parties prior to the report becoming final.
But at least
And-
there's some process where someone is challenging the credibility or testing the credibility of.
Which you have under the 15-16 policy as well.
And let's segue from that right into one of the criticisms that we've heard is, the statements were not reconciled. The inconsistencies were not reconciled in the review process. How do you address that?
I don't think there are inconsistencies, major inconsistencies with the reporting individual statements. If you look at page 305 and 310 of the record, her initial interview with Mariel Martin, the Deputy Title IX Coordinator, she very precisely outlines for Ms. Martin what transpired that night. that she was pressured into taking off her shirt, that she was pressured into taking off her pants, that the petitioner asked her to get into the bed, that they read for a little while, that he pressured her to take off her underwear, and then just proceeded to give her a back massage, at which point he penetrated her vagina with his penis repeatedly, against her will, without her consent, and despite her repeatedly saying, no, I don't want to have sex, and trying to physically push him off of her. So that is all very much and very clearly spelled out. And she makes reference to the fact that there was oral sex that she was pressured into performing. All of that is in her initial statement from October of 2014.
So you want us to focus on that, and that would be enough to uphold the
Your Honor, I believe that the statements that she made to the investigators and the statements that she made to all of the witnesses that are identified, with maybe some exceptions, witness 6, there was a bit of a different recounting. One of the first witnesses she spoke to was witness number 1, who detailed almost an identical set of facts that she told the investigator.
You started, and I don't think you concluded on how you addressed the lack of adequate notice.
Sure. I don't think there is a lack of adequate notice. The policy requires the date, time, location, and the factual allegations.
But all it was the provisions from the handbook.
It provided, it wasn't just that, Your Honor, with all due respect. It provided the date, the time, the location, including the room number. It included the name of the reporting individual. And when he met with the investigator during his initial meeting with his attorney, they provided him with an overview of the facts. And if you look at his interview from that meeting, he's very capable of detailing in quite a bit of detail about what transpired that evening with himself and the reporting individual. So there's no prejudice. It doesn't seem as though he's having any difficulty in recounting what happened that night. And then the notice itself, and under the New York State law, only requires the date, time, location, and the facts, as well as the policy provisions and the appropriate sanctions. And that is all contained in that notice, as well as the conversation that they had with him at the time that they met with him for the interview.
And my recollection is that the other, what was identified as a major discrepancy in the application was, having the other witness present, 2 people
Sure.
during an interview. My recollection is that you just think that's not a major violation.
I don't, Your Honor. The final determination that's being reviewed here really is the appeal panel's determination, and the appeal panel at Skidmore College reviewed this and noted that there was an error and set that witness statement aside in their review of it, and still concluded that there was sufficient evidence based on the record that there was a violation of the policy. So even from Skidmore's own perception, from the appeal panel's determination, they didn't consider witness 10 statement.
Remind me, is it clearly stated in there that we set this aside in our determination?
They don't go as far as saying we're going to set it aside, but they say even not considering witness 10's statement, we feel as though there's adequate evidence in the record to demonstrate that he violated the policy.
Do you have a site? I'll find it, but if you have it, I
Not right offhand, Your Honor.
Okay, thank you. All right.
In closing, Your Honors, there is a rational basis for this determination. The college substantially followed its procedures. One point I'd like to point out is with respect to the presence of counsel during the commenting session. The petitioner had asked that his counsel be present and didn't follow the policy by providing 24 hours notice of Mr. Machete's appearance there, and is now asking that he be given flexibility despite saying that the college should have been following the policy to a T.
Okay, thanks.
Thank you, Your Honors.
If you look at page 85 of the record, it's clear that the policy here required detailed statement of the facts supporting the alleged violation. That's the exact phrase in the rule or the guideline, whatever we want to call the policy, and they violated that. There was no way that this young man knew when he was speaking to the investigator and they were taking his statement what the factual allegations were. Matter of fact, he didn't know anything about the oral sex that counsel mentioned until he saw the draft report. Also, the answers to the questions that he gave her responses were not given to him until just before the adjudication panel. So he had no opportunity to review those with his attorney or to formulate his responses. I think that the fact that he wasn't given the hearing, which he and his attorney expected, is really a major deviation here, because As you know from the most recent case, the Cortland case, that was a 6-hour hearing in that case. Here, he had 15 minutes on the seat of his pants after getting these responses from her to try to defend himself. I think that that is not a fundamental fairness. I would suggest the University of Southern California case clearly says that meaningful notice requires detailed facts, that just citing sections of the policy is not adequate, and that's exactly what happened here. That's exactly how this investigation began. Also, I would suggest you look at the record pages 157, 193, and 389. Those are just 3 examples of her contradictions and how her statements changed over time. And certainly, there should have been some process of asking her why these statements were so drastically dissimilar. She unquestionably told witness 6 that she did not have sex. She also made the same statement to witness number 2. So I would request that you look at this in terms of the cumulative variations from the policy, because when you put them all together, this young man was denied an impartial and level playing field. Thank you.
Thank you both.